Good morning, everyone. It's 8:04 a.m. on June 9th, 2023. This is the meeting of the Texas Medical Board. This meeting will be open to the public at the above location and will proceed by video conference as allowed under Texas Government Code Section 155.127. The location above shall have two-way audio-video communication with each of the other locations during the meeting. The president or presiding officer of the board will be physically present at the location and room listed above. Please note that accommodations will be available for members of the public to physically attend the meeting at the above location, but will be subject to limitations set out by the Texas Facilities Commission seating. Members of the public are encouraged to attend the meeting by accessing the video conference or audio links below. For instructions using Microsoft Teams, there's a link that folks can refer to. All right, with that, we'll go ahead and call the full board to order and have roll call, please.
Okay, and the time is 8:05 for the record, and I'll call the roll. Dr. Zafran.
Present.
Dr. Farmer.
Present.
Mr. Kokonos.
Present.
Ms. Barnes.
Present.
Dr. Badia.
Present.
Dr. Deloach. Dr. DeStefano.
Present.
Mr. Gracia. Ms. Harrod. Dr. Martinez.
Here.
Ms. Morgan. Dr. Naidu. I think you're on mute, Dr. Naidu. I see you though. Okay.
But present, sorry.
Thank you. Dr. Nyack.
Present.
Dr. Quinones.
Present.
Dr. Tibbles.
Present.
Ms. Todd. And Dr. Vanderwide.
Yes, sir.
Okay, Dr. Zafran, you have a quorum and can proceed.
Thank you. Our mission is to protect and enhance the public's health, safety, and welfare by establishing and maintaining standards of excellence used in regulating the practice of medicine and ensuring quality health care for the citizens of Texas through licensure, discipline, and education. With that, I will start off with the board member report. Is Mr. Carlton on?
Yes, good morning. I'm here for a few minutes.
Thanks. I will defer a couple of minutes of my board member report to Mr. Carlton since he's only going to be able to be on for a couple of minutes. But just to kind of segue, we just ended the regular legislative session. The medical board had several issues, but more importantly, the agenda, the budget that was important for our continued operations. But we will be giving a little bit more of a comprehensive legislative update later on. But I wanted Brent to chime in at the very beginning also. Brent, go ahead.
Great. Yes. Good morning, everybody. Sorry, I'm not there with you in person or virtually. As you can see, I've traded in my my suit for today. Having to do some military duty. Of course, they only do this once a year, and it happens to be right now. So again, good morning. Good to see you all. As a quick just recap, as Dr. Zafran said, we did finish the legislative session. There were a lot of bills that we tracked. And Tori will be able to go over those with you. But in the end, we did get some good pieces of legislation passed through the legislature. Still waiting on the governor to sign them, but they are things that are going to help greatly with our operations, with our efficiency, to help our staff and our licensees. It's going to help our enforcement with allowing continuous query of the National Practitioner Data Bank. It's going to allow us to do the fingerprinting of all of our licensees, even the ones that were licensed before fingerprinting was required. And that'll allow us to get real-time updates on arrests and convictions. And so it ended up being a pretty exciting time for the board and what we're able to get. And it just took an immense amount of work from the staff and from our board members and from advocates out there to talk to the legislature and really let them know what we needed to help take the medical board to the next level. And Joey will be able to go have more time to go over some of the finances, but we asked for a lot and we got most of it when it came to our budget requests. And so we're working through what that's going to look like now that, once the governor signs it, assuming he does, but we're looking through what that's going to look like for our staff as far as increased pay and new positions to help spread the workload. So it turned out to be a very successful session, and I did want to take just a few minutes to let you know that, and to give my appreciation to the staff and for all the board members for your help in making all of this possible.
Thank you, Brent. And again, thank you for your service. I know you're out there doing a lot for us out there, even though you're not wearing a full suit. But I think everybody's looking at you, and again, just thanking and appreciating what you're doing out there. So thank you again.
Yes, thank you all. Any quick questions for me? I got just about 2 more minutes I can stay. All right.
Thank
well,
you
again,
for your service.
Oh, well, thank you. I appreciate it. If I know you guys have a good agenda today with a few PFDs, so I might be able to join you at the end if you're still on by then. But hopefully you're not and you're through. But maybe I'll be seeing you here in just a few hours. But take care, and please let me know if you have any questions. And I look forward to seeing you all. The August meeting will probably still be virtual due to the new boardroom not being complete yet downstairs, but we are targeting trying to do a full board meeting in October. So not too far off, trying to get everyone together again after about 3.5 years.
Great. Thanks, Brent. I'll talk to you later on.
All right. Thank you all.
All right, thank you, everyone. And again, we'll get into a little bit more of the detail on the specific changes that are exciting, especially around the PHP and some of the things that we'll be able to provide for our licensees that I think will be extremely impactful, especially from a funding standpoint, especially from their ability to access PHP without having to pay significantly additional dollars. So hopefully that will mean that more of our licensees will be able to participate and be able to utilize the services that the PHP is able to provide. The other issues which were of concern, again, the medical board did not have active querying of the National Practitioner Data Bank. It was really reliant on self-reporting by our licensees. That created a lot of concern, especially when there were folks who might have had arrests or convictions, and we didn't necessarily know about it until later on. Sometimes from media reports, actually, not even from our ability to get that information directly, as well as the fingerprinting, which was essentially only authorized for new licensees, but it wasn't required or mandated for licensees prior to when the legislation had passed. So the new bit of legislation that has passed will now provide funding for continuous monitoring of the National Practitioner Data Bank. So we will be able to get all this information in real time, and we'll be able to update physician profiles and all our licensees' profiles in real time, and have that information available to the public on their profile. The fingerprinting, again, will be for everyone now. There will be a period of time between now and I presume it's going to be with license renewal that it'll be mandated.
Yeah.
So as everybody renews their license, they will be required to have the fingerprinting done. And again, that will allow us to have information if there are arrests, convictions, anything like that. We will be able to get that information quickly. This is something that was a concern of the public that was brought to us, whether it was by the media or by certain legislators who raised that as a concern. We essentially said that would be great, but we would need to have the authority and the funding to be able to do so. And so we were all able to come together and provide the request for what would be needed, and legislators in both the Senate and the House were, put that through. And as Brent alluded to, it passed, and it just needs the signature of the governor. Broadly, as everybody knows, the cost of living has increased significantly. It's been very, very difficult to keep on very good, our good staff, even though they've been doing a great job and they continue to do a great job, but it's hard to do a great job when you're doing it with less people. So the funding requests that have passed, number one, to allow for cost of living increases adjusted for inflation, but also for additional FTEs so that we can fully run our investigative team. We can fully have our lawyers staffed up to a level that that is needed, especially since the compact, we have significantly more licensees, but we weren't able to actually hire on more folks. So that funding has passed also. And again, it would be, it gives us the ability to hire on more folks. But again, all the staff that are on there now able to get appropriate increases in their salaries adjusted for inflation. Everybody knows how expensive it is to live in Austin these days. So happy to say that that we will be able to take care of them now. So again, between Joey with the budget and Tori with the legislative update, they'll be able to go into a little bit more detail. But I do want to thank a lot of the board members who did reach out to legislators and spoke about the importance of getting our appropriate funding, especially since things were kind of on a standstill during the pandemic. We're past that now, and we're able to move forward. And also happy to say, and if there are any licensees who are on the line, or the members of the public know how our website is not exactly up to date and fast and robust, but it does take money and it does take resources to fix that. That we now have the funding to revamp our website and make changes to it. So again, a lot of exciting changes, a lot of exciting things moving forward, and gives us more of an ability to help serve the public by improving our call center, improving our call times, as well as the accessing of the website itself. So there we go. With that, I will proceed on to the next item, which is presentation, recommendation, and possible action relating to the internal audit. Mr. Graves, I know you gave us a little bit of a report yesterday, but the floor is yours. Go ahead.
Well, thank you very much. Yes, we gave a quick update to the executive committee yesterday. We had one internal audit on the plan for this year. That was the internal audit over enforcement. We issued that report on May 3rd. That report received a satisfactory rating. To just refresh your memory, there's 3 ratings: strong, satisfactory, and unsatisfactory. Again, this received a satisfactory. We identified 3 findings, 1 low and 2 moderate risk rated findings. One was one of the findings around monitoring complaint classifications was just a documentation issue, and that is a low risk rated finding. There was the last 2 are moderately rated. One over the completion of compliance forms that was centered around 1 compliance officer and the way they were updating compliance forms and performing that duty in a timely manner. That has already been addressed by the board, as well as the last finding, user access to SQL Tracer. We identified some user access that did not align with the user's job function, and so we brought that to the attention, and that is to be addressed by the board by January of 2024. In addition to that, we are in the middle of performing our follow-ups of the 4 audits that have been previously completed. Well, three previously completed and 1 that was from the SAO. So the findings over the Texas PHP revenue and registration audits, we're in the middle of following up on those, as well as following up on the closure of issues that were identified by the SAO in their cybersecurity audit. And so we will provide those to you at the next meeting, as well as our annual internal audit report and the internal audit plan for fiscal year 2024. And so those will be forthcoming. With that, those are all the comments I have, and we'll open for any questions over the detail of the report or our follow-up activities.
Thank you, Mr. Graves. Does anyone have any questions for Mr. Graves? All right, great. Thank you. And thank you, Mr. Graves, for your update, and look forward to continue addressing the issues that come up with the audit.
Thank you very much.
All right, with that, we're going to proceed to agenda item number 4, consideration and possible action for dispositions below minimum guidelines. With all these items, I would just remind the board members that we will offer times for folks to recuse themselves if they feel the need to. Mr. Freshour, before I proceed on, I'm going to let you give the standard spiel on the rules around recusal.
Okay. Well, it's pretty straightforward. If there's someone you recognize, work with, have some association with, or just generally don't feel comfortable with ruling on them because of a professional relationship or association, that type of thing, you can recuse yourself. You don't have to if you think you can be impartial, but it is always better to err on the side of doing that if you're uncertain. But those are generally the standards you look at. And if you have any questions, you can always ask. I mean, there are a lot of colleagues you may know very tangentially, particularly when it comes to agreed orders. It's not quite as serious. But again, Dr. Safran, I'll take a moment of privilege here. When it happens at ISCs and you know someone or you think you might have a conflict, what you need to do is to notify the hearings council, discuss it. And if you identify someone, say, look, I can be completely impartial, fair, whatever the association was, it's not an issue, or whatever the interaction was. But the key there is to announce that at the ISC, because if it occurs after the ISC or you don't say it and the other side then identifies it, there is a chance it will be spun into a perception of somehow, you know, wasn't quite up and up. So I'm taking this moment of privilege and I'm reminding not only you all, but I'm reminding the hearings council, myself, if we're in ISCs, whenever you say that, and you've run into it before, we have to make sure we tell the other side at the ISC. And even if they say, well, we're not happy with it, if you say, I can be fair and impartial, and I'm telling you that, and I'm telling you I recognized it, and they want to, you know, have an issue with it, there's other ways to remedy that. But the key is you've got to disclose it to them and not say anything out loud, because if it's after the fact, it becomes much harder to deal with. So again, thank you, Dr. Safran. I appreciate the latitude.
Thank you, Mr. Freshour. All right, so with that, I'm going to move on to agenda item number 4, consideration and possible action for dispositions below minimum guidelines. There are several items under that. Are there any extractions or recusals? All right, with that, I will entertain a motion on agenda item number 4. And remember that you need to specifically identify what your motion is on that agenda item.
Move to accept consideration approval mediated settlement orders numbers 1 through 5. So sorry,
Right.
number
1 through 6.
1
Thank
through
you,
6.
Dr. Bhatia. Is there a second?
Second, Quinones.
Thank you, Dr. Quinones. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? All right, motion passes. Agenda item number 5, consideration and approval of mediated settlement agreed orders. Are there any extractions or recusals on agenda item number 5? Seeing none, is there a motion on agenda item number 5?
Motion of approval of items under number 5, 1 through 5. DeStefano.
Thank you. Is there a second?
Everyone.
Thank you, Dr. Bennerwide. Any discussion? All those in favor, please say aye.
Aye.
All those opposed? Agenda item number 5 passes. Agenda item number 6. And there are several items under there. Consideration and possible action for remedial plans, administrative rules, crime laws, impairment, peer review, state action, which has none under there, standard of care, unprofessional conduct, and late orders. For agenda item number 6 as a whole, are there any extractions or recusals?
Yes.
Dr. Bhatia, are you extracting or are you
standard-
recusing?
Recusing standard of care number 30.
Okay. Any other recusals? All right, thank you. So on agenda item number 6, is there a motion?
Move to accept consideration and possible action remedial plans 1 through 41, and again with me recusing number 30.
Second, Vanderwide.
Thank you. Is there any discussion? All right, with that, all in favor, please say aye.
Aye.
All opposed? Agenda item number 6 passes. Agenda item number 7, consideration and possible action for agreed orders. Again, several sub areas on that one: administrative rules, crime laws, impairment, peer review state action, standard of care, unprofessional conduct, and late orders. Are there any extractions or recusals on agenda item number 7? All right, with that, is there a motion on agenda item number 7?
There's a motion, item 7 from Dr. Naidu.
And your motion is to approve consideration and possible actions for agreed orders. Is that correct?
Yes, sir.
Okay, is there a second?
Second Barnes.
Okay.
Second.
Is there any further discussion? All those in favor, please say aye.
Aye.
All those opposed? Agenda item number 7 passes. Agenda item number 8, consideration and approval of modification request, termination request orders. Is there any extractions or recusals on agenda item number 8? Seeing none, is there a motion on agenda item number 8?
Move to accept consideration and approval of modification request, termination request orders, Vanderwide.
Thank you, Dr. Vanderwide. Second to Stefano. Is there any further discussion? All those in favor, please say aye.
Aye.
All those opposed? Agenda item number 8 passes. Agenda item number 9, consideration and approval of modification request, termination request of non-public rehabilitation orders. There are none there. Number 10, consideration and approval of cease and desist orders. There's a couple there. Is there any extractions or recusals on agenda item number 10? Seeing none, is there a motion on agenda item number 10?
Motion to accept consideration approval of the cease and desist orders, item number 10, Barnes.
Thank you, Ms. Barnes. Is there a second?
Second, Farmer.
Thank you, Dr. Farmer. Is there any further discussion? All those in favor, please say aye.
Aye.
All those opposed? Agenda item number 10 passes. Agenda item number 11, there's none there. Number 12, there's none there. Number 13, there is none there. All right, with that, it is almost 8:30. Our next agenda item, number 14, needed to be at least at 8:10, so it's appropriate for us to proceed on there. It is consideration and approval of determination of default for Dr. Carrie Fechter. Ms. Swanholm, I will let you proceed on.
All right. Thank you, Dr. Zafran. We have in front of you today a proposed default order against Dr. Carrie Fetcher. So a complaint was filed on February 7th, 2023, alleging that Dr. Fetcher engaged in unprofessional conduct with 3 patients, that he closed his practice without any notice to his patients or with changing any of the advertisements that led to patients coming to the practice seeking specific types of care. He also failed to provide any instructions on how to access medical records to any of his patient populations, and then specifically failed to provide medical records to patients who requested them after his practice closed. Throughout the SOA proceeding, there's been no response. He's filed no motions. He's made no appearances. On April 5th, the hearing on the merits was held after duly notice to him. A default order was issued when he did not show up to the hearing on the merits, and board staff has in front of you today a proposed default order. This is based on Dr. Fetcher's failure to participate or to appear at all in this proceeding, or to communicate with board staff about trying to resolve this matter without having to go to this route. Thank you.
Yeah, thank you, Ms. Swanholm. Is Dr. Fetcher here, present? Okay, Dr. Fetcher, I'm going to give you another 5 seconds. If you're present, please identify yourself. Okay. So with that, we're going to take up consideration of determination of default. Is there any discussion on this item from the board members? Okay, I will entertain a motion on the determination of default.
So move Martinez.
Second Bhatia.
So, Dr. Martinez, you are,
Consideration and approval of determination of default for Dr. Carey Fetcher.
right, thank you, and seconded by Dr. Bhatia. Is there any discussion on that? Seeing none, all those in favor, please say aye.
Aye.
All those opposed? All right, agenda item number 14 passes. Okay. All right, so before we start the proposals for decision, it is 8:30, and if we wanted to take public comments, we are able to do so from 8:30. So seeing that there are some guests here, and rather than have them wait, we don't know how long these PFDs will take. We'll go ahead and start the opportunity for public comment first, and then proceed on with the proposals for decision. So I will hand this off to Mr. Palazzola. And we will do the public comment period first. Remember that with this is an opportunity for members of the public to speak. We give them
Three minutes.
3 minutes. This is not a question answer session. There's just an opportunity to make statements, to provide information, whatever that might be. This is not about engaging back and forth. And I would also caution members of the public that this is also not about addressing issues and items that are before the board directly. That is not the appropriate place or time or forum for that. So if you have an issue specifically in front of the board, again, you can say what you want to say, but this is not a forum for us to adjudicate that, especially if these are items that have already been decided. But we will proceed on from there. So, Mr. Palazzola?
Sure. And if anyone, there's just noting for the record, there's nobody in the room with us from the public today, but if anybody is signed on to the meeting that would like to address the board, this would be the opportunity to do it, subject to the conditions Dr. Zafran just pointed out. If you can raise your hand, you can raise your hand, or you can just take yourself off of mute, and we'll take it one at a time. Is there anybody that wishes to make a public comment at this time? We'll give it a few seconds here to see if anybody takes themselves off mute.
Yes, I'm Linda Bailey. I would like to make a comment.
Sure. Okay. And we can give you 3 minutes to do that, and we'll start your time. Please do let us know, your topic, and you can proceed.
Okay, I understand that Dr. Kenneth Haygood is before you this morning for
Okay, ma'am.
For the hearing.
Okay,
Yeah.
ma'am, I do need to remind you, as Dr. Zafran just pointed out, if that's a matter that is currently pending before the board, this would not be the appropriate point to take any comment for it. The board is going to be considering that matter in a short while. You of course would have, once it's a decided matter by the board, you could make a public comment about it, but that would be at a later date.
Well, and I will give them an opportunity later on.
Okay, and Dr. Zafran has indicated we will come back to public comment after that matter to give you another opportunity, since you have taken the time today to join us. So, but we cannot accept any public comment on that matter prior to the board's consideration of it.
Okay, I understand. I appreciate that.
Okay. Thank you, ma'am. Is there anyone else wishing to make a public comment today? Okay. I think it's okay. We'll come back to this item later. Thank you.
All right. So with that, we'll proceed on to agenda item number 15, which is consideration and approval of proposal for decisions. There are 3 PFDs that are listed on here. We will take each item on individually. I will again hand off to Mr. Palazzolo to explain to everyone how this process works, and of course go through the process of how much time each side has and what the process is around discussing it, and then we'll go on from there. So, Mr. Palazzolo.
Certainly. And the first proposal for decision we're going to take up will be the matter of Kenneth Haygood. I believe Dr. Haygood is here. Dr. Haygood, are you appearing with counsel today, or are you representing yourself?
No, sir, I'm by myself.
Okay, so Dr. Haygood will be representing himself. The way this will work is each side will be given 10 minutes to make a presentation. Board staff did have the burden of proof at SOA, and they will have the opportunity to make the first statement. They can reserve some of their time and return and make a closing statement. Dr. Haygood will be given his 10 minutes all at one time. The board members will have an opportunity to ask questions of both staff attorney and Dr. Haygood. However, would remind everyone that the record is set. And so this case did proceed through a State Office of Administrative hearing. A proposal for decision was issued, and the judge has already made findings of fact and entered conclusions of law. The board does not have the authority to change those findings of fact or conclusions of law. There are appeal rights that don't really apply in this case, but the general counsel could explain to you, but you don't have any ability to change the findings of fact or the conclusions of law at this point. This is really just to consider what appropriate decision regarding the final order that would be entered today would be based on the determination made by the judge. And then any appeal would come later to district court. And with that, Ms. Swanholm, are you representing staff on this one?
Shane Nelder will be representing staff today.
Okay. And as Mr. Nelder, are you online as well? He is. So
I am, sir.
With that, we're ready to start Mr. Nelder's time unless there are any procedural questions. Okay, thank you.
Good morning, board members. My name is Shane Neldner for board staff. I'd like to reserve whatever time I have left following this presentation for rebuttal. Respondent Kenneth Haygood holds medical license K2341. On January 25th, 2021, staff filed a complaint at SOA alleging that respondent failed to practice medicine in an acceptable professional manner consistent with public health and welfare and engage in unprofessional conduct when he performed a physical examination under the clothing of one patient after that patient had twice expressly refused consent to that physical examination. Respondent also failed to practice medicine in an acceptable professional manner consistent with public health and welfare and engaged in unprofessional conduct when he disclosed confidential and privileged physician-patient communications relative to or in connection with any professional services as a physician to the patient. After being duly noticed on June 9th, 2022, a hearing on the merits took place September 19th through 21st, 2022. And Administrative Law Judge Shenoy issued a proposal for decision. The judge's PFD, which board members will find in their packet, found overwhelmingly that respondent engaged in numerous violations and that his conduct was aggravated. And as Mr. Palazzolo said, we're here today to sanction respondent based on these findings that are in the record. The board doesn't have discretion to change the findings as they're laid out in the PFD. And it was established that respondent did engage in this conduct. Board staff has the findings to support and is recommending that respondent be publicly reprimanded, that his practice be restricted in that he may not see, examine, treat, or prescribe to, provide consultation for, or otherwise practice medicine on female patients, including telemedicine, that he be required to take and pass the JP exam, that he be required to complete the PACE program, that he take 24 hours of CME in ethics, communication, and in HIPAA, and that he'd be required to pay a $5,000 administrative penalty. Now, some of the findings that I wanted to go over with. In July 29th, 2019, the ALJ found that the patient, a 19-year-old woman, scheduled an appointment to discuss some blood results regarding hyperthyroidism. When she was in the examination room, she told respondent's medical assistant that she did not want a physical examination since she already had an examination at her gynecologist. The medical assistant left the room, told respondent and she returned to tell the patient that respondent still wanted to conduct the exam. The patient again declined. She wasn't prepared for a physical examination. She was not dressed for it. She was not wearing a sports bra or underwear as she usually did. She, in fact, wasn't wearing any underwear on the bottom. Now, before he entered the examination room, respondent knew that he had refused the skin check, as he called it, but nevertheless, without warning her, although he had done so in the past, he had alerted her, asked permission to examine parts of the body. He did. He lifted up her shirt over her shoulders, exposing the back and front of her bralette. He pulled back her leggings, looking down her pants. When she laid back to examine her stomach, she sat up in the middle of it because she wanted the exam to be over. And she testified that she felt awkward, confused. She was frozen. She felt violated. Her face was flushed. She felt sweaty and her heart started racing. None of this was noticed by or responded to by the respondent. Once the examination was over, she went out to her car, began to cry, called her mother, father, told them what happened, and then she filed a complaint. Now, following that, the ALJ found that respondent did not obtain patient's informed consent to conduct a physical examination. She found that as a result of the visit, the patient has lasting discomfort being treated by male healthcare providers, and that it has affected the physician-patient relationship. The patient testified, and this is in the record, that she took the experience to be a sexual assault, and she filed the complaint, consented to deposition, and appeared at SOA to verify all of this. Regarding the HIPAA complaint, she testified that, and we have evidence in the record and exhibits in the record, that after an investigation was opened and Dr. Haygood was notified that of the examination, he sent unsecured cell phone text messages to patient's mother, telling her that, asked her if she was aware that the patient had made a complaint about the visit, and that basically that her interactions with respondent were somehow intrusive or threatening. He described it as shocking, saying that she had a bad day and she was taking her frustrations against him by bringing this complaint that was damaging to himself and staff. He speculated that she might be suffering from abuse, fears, or anxiety, and additional information. But this constituted, the ALJ determined, as a disclosure of confidential medical information and protected health information. At no point did he go back and make a note of this in the medical record that he was concerned about abuse or anxiety or fears. He didn't make it initially. He didn't make any amendments to it either. And so the ALJ found that this was a HIPAA violation. There was no waiver. There was a waiver signed by the mother when she was 14, when the patient was 14, but there was no waiver after she turned 18. So again, remind the ALJ also found aggravating factors, knowing or gross negligent acts constituting a violation. There was a previous disciplinary action by the board against.
Mr. Elder, you do have under 2 minutes remaining, just letting you know.
Yes, sir. Against respondent and a peer review organization and other relevant circumstances. So we would ask the board to accept the final order that's in the packet, and I leave it to the board for their consideration.
You and Dr. Haygood, you will have 10 minutes for your presentation as well.
Thank you. Let me make sure my mic is on. Can y'all hear me okay?
Yes.
Okay, thank you. So thank you for the opportunity to address the board and the situation. Obviously, I disagree with that most of the conclusions and findings of the ALJ, and it's not too surprising that the ALJ had limited information to work on, going back to the fact that there really never was any adequate investigation by the board in the first place of the complaint. In fact, I was not even notified that there was a formal investigation initiated until many months later, and after a professional panel had already been convened and given limited information to try to make any decision on. I had not had any chance to even see the full complaint or respond to it or provide the follow-up information that clearly would have led to a different outcome from the physician panel. The board staff seemed to have ignored that and simply proceeded on with their information that they wanted toward their goals. There are just a few things I would take a moment to point out that are factually indisputable in the record. The patient in question scheduled not just an appointment to follow up her labs. She herself, the week before, scheduled her annual physical exam. She confirmed with my staff when she was brought back that day that yes, she did in fact want her annual physical exam. She and my staff, and then also I with the patient, upon entering the room, each individually confirmed with her the aspects of the exam that she wanted that day and those she didn't. I had referred her at my suggestion to a gynecologist the year before, and that part of her examination had already been taken care of, and I knew wasn't necessary. The patient knew wasn't necessary. And so in that regard, that was the first instance where she and my medical assistant discussed that simply acknowledging that as a reason that she didn't need to get fully undressed into a gown. The second question of whether she did want to get undressed anymore was simply for the performance of, if she felt it would make it easier for the performance of the rest of her physical exam, which she presented for that day. It's documented that the patient did confirm to my staff independently as well as to me that she did want the rest of her physical exam that day. She had had at least 4 prior physical exams in the past. A couple had been with her dressed in street clothes, somewhat similar to what she had that day. And a couple in the past, she had been undressed in gowns. And of course, with young, healthy patients, we do physicals to whatever degree are appropriate or requested by the patients in whatever form of dress they choose for the day. Her examination proceeded as normal. We talked about things in advance. The patient's characterization of the exam was incorrect, and all the documentation of the record goes toward that. Let me see. Contrary also to what the board staff have suggested, we do have signed consent for examination and other care, not only by the patient's mother, but also by the patient herself. And at no time did she rescind any aspect of that consent for her examination. The patient herself has acknowledged that at no time did she say to me or my staff, at no time did she submit in writing or communicate in any other way that she declined to have the aspects of her upper body examined that were briefly examined that day. She's admitted that under deposition, that she never communicated such a thing to my staff or to me. In fact, it was specifically discussed that the aspects of her exam that she did not want or need that day were a pelvic exam or further examination of her lower extremities. And as such, her exam was performed completely with her cooperation and carried out in the normal fashion, such that when the patient left, she did not leave, as the board staff have suggested, in any kind of hurry or disarray. In fact, the board staff is aware and has proof of documentation that the patient did stop at the front desk actually and take time to discuss her billing situation and schedule her follow-up appointment with me before leaving the office that day. Now, this is a patient who's an acknowledged activist who we found out later in the preceding months had been posting and sharing things online about how terrible doctors are who try to control women, and she clearly saw herself as something of an activist. We don't know exactly how that plays a part into the complaint that she later wrote that day. But in her complaint, she did accuse me of sexually assaulting her. She repeated that complaint to the ISC. She repeated that complaint in deposition. But then, in fact, on questioning, she acknowledged that at no point was she ever touched physically in any inappropriate way or a way that offended her during her exam. The fact is that during her exam, the only thing she complained of was the examination of the skin of her back, which was partial and brief, by simply lifting the back of her shirt about halfway up her back, partly up her back, moving her high-waisted leggings slightly an inch or so down her lower back. The patient herself has acknowledged that she has no idea what beyond her lower back, if anything, was exposed at the time. And nonetheless, she made the complaint. As to the suggestion that there was any inappropriate communication with the patient or her mother afterwards, the patient and her mother remained in contact with our office by phone, by text, by email, which were the patient and her mother's, the patient specifically, preferred method of communication with us, which they consented to, which the board has acknowledged is nothing inappropriate about that. And one of those communications to her mother, who had been integrally involved in all aspects of the patient's care before this visit and continuing after this visit, was about the patient's demeanor during that visit, and our concern that that something obviously had gone wrong, or that she had something had felt disturbed or so by our visit, and suggesting to her mother that we'd be open to talking with any of them about that if she or the patient desired. That was it. There was no private health information divulged to the mother that the mother did not already know. It was simply the patient's name and the fact that the patient had had a visit that day, and my concern for the patient's demeanor that day. This health information, the patient herself has acknowledged directly to the board that I had the patient's permission to communicate any private health information to her mother. And so for the board staff to try to suggest otherwise is really inappropriate. And then even further to suggest that this communication somehow was inappropriate or constituted some threat. The board's medical director himself stated that he felt that it would have been appropriate for me to contact the patient directly, which I disagreed with. I don't think would have been appropriate in the circumstances. But we were careful in any communications we did have to follow the letter of the law, to not say anything that would have been derogatory or questioning, to not reveal any additional information that wasn't necessary to the communication. And in fact, federal law protects these communications specifically at the discretion of the treating doctor if there's even any question about the consent for sharing this medical information. So again, the suggestion that there was some wrongdoing there is entirely disingenuous and disproven by the evidence, and goes against the letter of the law itself. Let me see for a second here. As far as the main problem with this, aside from the board's impropriety, the board staff impropriety, and all these things over the last 3 years, the main impact is to all of the other patients and the public that the board is supposed to be protecting. One complaint that should have been taken care of easily within a matter of weeks after it happened has drug on for 3 years to no surface to this patient at all. And now the board would suggest that well over 1,000, at least 1,500 patients who are innocent patients.
And Dr. Hagood, that is the Dr. Hagood, that is the end of the 10 minutes. If you could take just a few seconds to wrap up, please.
Thanks. My final point is that there are over 1,500 patients be entirely disenfranchised by this proposed order, half of which are female patients, a large portion of which are minority patients, at least 100 or so of which are uninsured patients who we care for, who this board's staff would suddenly cut off from care from their chosen physician for no reason at all, while the administrative law judge herself confirmed that whether there was an infraction or not, my actions do not constitute anything that represents any risk to the public or any other patients.
Okay, and
Thank you for
Mr. Neldner will have, you do have 3 minutes and 26 seconds left for rebuttal. Thank you.
Thank you. Just to start off, to remind the board respectfully that we're really litigating matters that were already decided by the ALJ at the hearing on the merits. However, Dr. Haygood does misrepresent the facts and evidence, the determinations made by the ALJ, and the testimony of the patient. The ALJ did find that the patient did not make a follow-up appointment at the end of the visit. The ALJ did find that when the patient turned 18, respondent did not obtain written authorization for him to disclose her personal health information, and did find that he did disclose personal health information. I would like to mention that this is not respondent's first time before the board. He has a prior disciplinary history, so he's aware of the process. In 2017, respondent entered into an agreed order pursuant to which he was required to complete 16 hours of CME, 4 hours in anger management, ethics, risk management, and communication with colleagues. This is related to peer review at Trinity Mother Frances Hospital through suspension of his privileges, and the chief basis of his peer review action was failure to complete a contested professional practice evaluation. The ALJ did find that respondent's misconduct toward the patient was exacerbated by his disclosure of PHI, personal health information, and confidential information without authorization, and by his text messages that were intended to intimidate the witness, that's the patient, and potentially her husband, about patient's statements used in an ongoing board investigation, and that he failed to obtain consent and knowingly disclosed it as well, that it was grossly negligent. And then in brief, I'll remind the board that the findings are not subject to change, but that something to consider when making a determination in this case is that he's been given multiple opportunities to remediate his behavior and has not changed. As noted by the judge, respondent continues to deny his behavior, continue to blame the patient for what has taken place here, and to continue to blame board staff for the process. He's refused to accept responsibility for his actions or show any remorse. So with that said, the board would request that the board staff would request that the board return an agreed order that would publicly reprimand the respondent, restrict his practice from treating female patients in any respect, the JP exam, PACE program, and the 24 hours of CME, and that he pay a $5,000 administrative penalty. Thank you.
Thank you. Before we proceed on, I just need to make something very, very clear. And I've seen a lot of respondents fall into this or try to do this here at these PFDs. And I want to make it absolutely clear, just so that it's clear to everybody and to the public what we have in front of us right now. When something goes to SOA, we have findings of fact in front of us. To try to relitigate that at this point over here is an absolute waste of your time. This is your opportunity to present mitigating factors as to why we should alter the agreed order that is proposed by staff. But to try to actually continue relitigating this at this forum really does you no good. And in fact, it kind of hurts because it shows no remorse whatsoever. At this point, we are not in a position to alter or to relitigate the facts that were accepted and presented by the administrative law judge. That's why it went to SOA. The findings of fact are the findings of fact. In fact, even if we wanted to, we can't. It's there, and it could have been in your favor. The findings of fact could have been in your favor, and we wouldn't be able to relitigate that. So it actually works both ways. So just for future purposes, for the public to understand that when we get to this point, it is not an area to relitigate. It is not an area to try to reconsider the facts that are out there. It does you no good to keep on trying to relitigate that over here in front of the board. In front of us are the facts, and in front of us are really just the mitigating factors to alter what that order may or may not be. So anyway, I just had to say that. With that, are there any questions by the board members to either the staff or to Dr. Haygood? All right, seeing none, I
Would you like a
will.
motion at this point? Are we doing these individually?
Yes, we
need
are.
to- Yeah, yeah.
Yes, we are.
Would this
So,
be a time
Ms.
for?
Barnes?
Oh, okay. I'd like to make a motion then, please, sir. I move that the board adopt the findings of fact and conclusions of law of the administrative law judge in the proposal for decision and approve the suggested final order in the matter by board staff.
All right, a motion has been made by Ms. Barnes. Is there a second?
I'll second it, Farmer.
Seconded by Dr. Farmer. Is there any further discussion? Seeing none, we'll proceed on to a vote. All those in favor, please say aye.
Aye.
All those opposed? All right, motion passes.
Dr. Zaffron, if
Yeah.
I may, I'd request that a poll be taken of the members as to which ones voted aye and which ones voted nay. Thank you.
There were no nay votes. Everybody voted aye.
Thank you.
And were there any abstentions? I can just, we can just ask that question specifically. There were not. So everyone voted aye, no one voted no, and there were no abstentions. All right. With that, I will proceed on to the next item, which is Donna Elaine Winningham. I will proceed on. Mr. Palazzola.
Certainly, and this will very similar to the last one. First of all, is there anybody representing Dr. Winningham signed on to the meeting? And I don't believe there is. We have been keeping track of people as they log on, and I don't think we do have anyone from Ms. Winningham. Ms. Swanholm is going to do this presentation for board staff. We'll start the clock at 10 minutes, but of course, Dr. Winningham is not here, so may not use the whole 10 minutes, but we will give her 10 minutes. And then if there are questions after the presentation, the board members will have the opportunity to put any questions to her. Thank you.
All right, thank you, Mr. Palazzola. I'll keep this brief then. So on March 25th, 2022, TMB staff filed a complaint at SOA. The allegations included that respondent's California medical license was revoked based on an extensive board history in California and her failure to adhere to the board orders that were previously entered. Generally, she suffered from a substance use disorder and was directed to abstain from the use of alcohol. She was unable to do so, and based on that, her California license was revoked. Board staff filed a motion for summary judgment that resolved this matter because the Medical Practice Act is very clear that if a licensee is revoked in another state, that the medical board, the Texas Medical Board, shall revoke their license in Texas. The ALJ issued that order, and we proceeded to a hearing on the merits that only discussed aggravating and mitigating factors. That hearing on the merits was held on January 24th, 2023. The board argued for several aggravating factors. Dr. Winningham argued for several mitigating factors. The ALJ found one mitigating factor and one aggravating factor. The mitigating factor that was found was prior community service and present value to the community. Specifically, the ALJ found that there is a need for radiologists in Texas due to COVID-19. She also found that respondent is not an alcoholic. Aggravating factors that were found: one aggravating factor, the rule is other relevant circumstances increasing the seriousness of the conduct, and the facts behind that the ALJ found was that respondent showed an inability to abide by the California order, notably an inability to maintain sobriety and to abstain from the use of alcohol, and a failure to acknowledge that she had agreed to this order and that she was required to abide by it, and she did not. So in front of you, you have a proposed board order that would adopt the findings of fact and conclusions of law and recommend sanctions based on the aggravating factors that were found, taking into account the mitigating factors. But essentially, because you, per the Medical Practice Act, shall revoke, this order would revoke her license in Texas. I'm available for questions, but we would ask that you vote to adopt this order in front of you today. Thank you.
Thank you, Ms. Swanholm. Again, I'm going to give an opportunity to see if Dr. Winningham is here. And is there anyone from opposing counsel present? Okay, seeing none, that proposal for decision is in front of you. Is there any discussion by board members? Seeing none, is there a motion from the board members?
Dr. Sanford, Kokonos, I'll make a motion to agenda item number 15, Donna Elaine Winningham, MD, to adopt it as recommended by board staff.
Thank you, Mr. Kokonos. A motion has been made. Is there a second?
I'll second Farmer.
Seconded by Dr. Farmer. Is there any further discussion? Seeing none, we'll proceed on to a vote. Is all those in favor, please say aye.
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 All those that are nay? Are there any abstentions? All right, so there were no nays and there were no abstentions, so the proposal passes. The third proposal for decision is Dr. Tara Netter, and I will hand it off to Mr. Palazzolo again.
Certainly. Is there anyone here representing Dr. Netter? I believe so. So once again, very similar. Mr. Neldner will have up to 10 minutes to present the summary and recommendation from board staff. We'll make one more call to see if anyone is here for Dr. Netter and then open it up for a vote. Mr. Neldner, you can start.
Good morning again. I'd like to reserve whatever time I may have left if necessary following this presentation if I need to do a rebuttal. Dr. Netter holds medical license number P8166. On March 31st, 2021, staff filed a complaint at SOA alleging that respondent failed to participate in the Texas Physician Health Program and referred her to the board due to noncompliance with her agreement. Specifically, respondent missed several drug tests and respondent is noncompliant with Alcoholics Anonymous meetings for substance use disorder issues. Respondent was unable to practice medicine with all reasonable skill and safety to patients as a result of excessive use of drugs, narcotics, chemicals, or other substances, or any mental or physical condition. And respondent engaged in unprofessional conduct when she violated state or federal law. Specifically, that's number 12, substance use or substance diversion. On May 26, 2022, staff filed an amended formal complaint, additionally adding that she violated section 164.051A9 of the Act. That's disciplinary action by another state board. On September 19th, 2022, staff moved for summary disposition, to which a respondent did not file a response. Then the ALJ, Amy Davis, on October 11th, 2022, granted the MSD, concluding that she was subject to sanction by the board based on the Colorado agreed order. ALJ Davis further determined that a hearing to establish an evidentiary record concerning aggravating and mitigating factors was necessary. She was notified of the time, place, and nature of the hearing, provided with a statement of legal authority, everything above board. And then on October 12th, the evidentiary hearing concerning those aggravating and mitigating factors was held via Zoom by ALJ Davis. Former staff attorney Preston Tom represented the staff. However, the respondent failed to appear at the hearing. The record closed on January 4th, 2023, and the ALJ issued a proposal for decision on February 15th. The PFD, which board members have in their packet, found that respondent had engaged in numerous violations and that her conduct was aggravated. The conduct was as follows: that she signed a PHP monitoring agreement. She failed to complete drug tests on 2 occasions, failed to check in with her monitoring service on 3 occasions, and tested on the incorrect day at least once. She was placed on a zero tolerance plan due to her noncompliance. She was terminated from Texas PHP and referred to board for disciplinary action. The Colorado Medical Board entered an order finding that respondent failed to report to the Colorado Medical Board within 30 days of pleading guilty to the misdemeanor charge of driving while impaired and failed to report a physical illness, physical condition, behavior, mental health, or substance use disorder that impacted her ability to perform a medical service with reasonable skill and safety. In the Colorado agreed order, the board accepted respondent's surrender of her Colorado medical license for a period of 2 years. And that agreed order has not been set aside, deemed void or voidable by any court. The ALJ's aggravating factors that were found: increased harm to the public regarding the serious history of her alcohol abuse, and intentional, premeditated, knowing, or grossly negligent act constituting a violation, driving while impaired in Colorado. There were no mitigating factors. The board staff is moving the board to revoke respondent's medical license. And so that final order is before the board currently, and I would submit it to them for their approval. Thank you.
Thank you. Again, I'll give an opportunity. Is Dr. Netter or a representative present? Seeing none, we'll proceed
I'd
on
like to make a motion.
Okay, is there any discussion beforehand? All right, seeing none, Ms. Barnes?
Yes, I move that the board adopt the findings of fact and conclusions of law of the administrative law judge in the proposal for decision and approve the suggested final order filed in this matter by board staff or Dr. Netter.
Second.
All right, a motion has been made by Ms. Barnes and it's been seconded by Dr. Bhatia. Is there any further discussion? Seeing none, all those in favor of the motion, please say aye.
Aye.
All those opposed? Any abstentions? All right, motion passes. Thank you very much. All right, with that, I am going to go back to the public comment again, and I will give an opportunity for those who would like to make any public comments, the opportunity to do so. Mr. Palazzolo?
Certainly, and I do believe the individual that was going to speak earlier is still with us. Would you like to go ahead and make your public comment now, ma'am? Giving it just a little bit longer. If you take time to take yourself off of mute, or if there's anyone else that's joined the meeting in the last several minutes that would like to make a public comment, now would be a time to do that as well.
This is Linda Bailey. Is this where I can make a public comment?
Yes, ma'am. You do have 3 minutes, and you can make your comment now.
Okay, I would just like for y'all to know some of the things that Dr. Haygood has done for me since I moved to Tyler. Dr. Hay, I was diagnosed with cancer in August or June of 2021, and Dr. Haygood had made some referrals here in town. I have interstitial lung disease and polymyositis, and the doctors here in town wanted to do radiation, which was going to take another part of my lungs away. And Dr. Haygood made numerous phone calls to doctors in Houston in order to get me additional medical treatment. And my family could not attend the surgery because my mother's 83 years old. My brother lived in Alaska, and my sister was not vaccinated. Dr. Haygood went with me to Houston and met with the doctors there and went through surgery with me and met with my pulmonologist there, and he coordinated all of my care. He also helped with my husband who had Alzheimer's disease. And there was an instance where my husband had been hospitalized for his Alzheimer's disease, and I had been diagnosed that same week with double pneumonia. And at the very same time, my dog Sadie died. And Dr. Haygood had called me to confirm that the CT scan had revealed that I had pneumonia. And when he asked me if I had gone to pick up my medication yet, and I told him that I had a dog who had died in my room and I couldn't leave. Dr. Haygood came over and buried my dog for me because I didn't have any family that could come over and do that for me. And he took extra steps. And then he would always go see my husband at the memory care unit because it was always so confusing to Jim whenever I had to bring him back and forth to the doctor from the memory care unit. He didn't understand where we were going or what we were doing. But Dr. Haygood would go there and see him and just talk with him there. And Jim would not get as agitated. He wouldn't get as irritated, and he wouldn't get as confused as when these things had happened. And he did all these things outside of the scope of what he would normally do from 8 to 5. And he doesn't work 8 to 5. People call him and he comes in on Saturdays. He treats patients and children whenever they call, whether it's 9 o'clock at night or whether it's, on a Saturday morning.
Ms.
And
Bailey?
he has made himself available to the point where so many doctors had to shut their doors at 5 o'clock and
Ms.
said,
Bailey?
go to an urgent care clinic.
Ms. Bailey,
And
thank you.
he has
Ms.
done
Bailey,
these things for me and for
Ms. Bailey, thank
countless
you so
other
much.
patients. And for that, I will be eternally grateful for him because he did those things. And I can't stress, I cannot stress that enough, especially
Bailey.
what he did for my husband. And when my husband died, I was alone here in Tyler without family. And he actually.
Sorry about that. I had to mute you. I gave you another minute or two after the 3 minutes. Thank you so much for coming and presenting a statement. I appreciate you taking the time to do so. Are there any other folks from the public that would like to speak at this moment? Okay, seeing none, we will proceed on. Executive Director report, as we mentioned earlier, Mr. Carlton is serving in the military for this period of time, so he's not here. I will give an opportunity if is Joey present?
Yes, sir, I'm here.
Joey, would you like to at least give a budget update and make any remarks as far as what we have moving forward and so forth?
Absolutely. Thank you. Good morning, board members. So I'll be brief. So in your board packet, you should have 2 reports available for you to review. The first one is the executive report, which provides a snapshot of the agency's financials through the end of May. So starting on page 3, that gives an overview of the expenditures for the agency. Currently, the agency is at 94.7 budget execution. The remaining 5% of that budget we have on reserve for emergencies or anything that might pop up through the end of the year. We do have projects in place to use the 5% remaining if they become available at the end of the year. And starting on page 8, there's an overview of revenue collections by license type. This information does go all the way back to fiscal year 2012. Currently, for this fiscal year through the end of May, the agency has collected $28.6 million. So that is 96.3% of what we reported to the legislators that we would collect for the year. So that's great for us. We're almost at 100% of our budget collection. And trending for the end of the fiscal year, we should collect just over $37 million. The executive report also includes additional information on the different types of accounts and funds for reference, and then also provide an analysis on variances between the fiscal years for revenue collections that are over 10% for informational purpose in case anybody has additional questions on that. The second report that I've provided is an update on our legislative appropriations request. So the budget bill did go to the governor's office for signature yesterday. It's still pending signature, so a lot could happen between now and before that happens. But we don't anticipate really anything impacting our budget and how that's playing out. But just to give an overview of the outcome of the legislators, the agency did receive an additional 14.3 million on top of our baseline budget, which is typically about 29 to 30 million for the biennium. So that's great for us. We have a lot of room now for increasing our operations and whatnot. Out of that 14.3 million, 1.7 million is set aside for one-time capital projects. So we have 5 major capital budget projects that we will be executing in fiscal year 24 and 25. Compared to the last biennium, the agency is showing, or the agency will receive 38.3% more in appropriations. Our overall budget baseline specific for operations, excluding one-time capital projects, have increased 42.3%. Comparing our appropriations to our revenue collections, we should see a significant increase. To that, traditionally, we were only receiving 40% of what we collected. Comparing our current appropriations, once it's signed, to what we collected in fiscal year 2022, that's about 53.7%. So we should see an increase of about 14% more in getting back the revenues that we collect. And just to point out, as Dr. Zafran mentioned yesterday, although that is a significant increase for us and great news, it still does not compare to what some of the other agencies in Article 8 are receiving. There is still a handful of agencies that receive 70% or more of the revenues they collect. So we've got some more work to do at the next session. And then also the agency was authorized an additional 35.5 additional FTEs. So we're excited to have those additional FTEs to support our operations. These are permanent FTEs. So our authorized count is going from 224.5 to 260 now. So pending any questions, I will hand it back to you, Dr. Zafran.
Thank you, Joey. Is there any questions for Mr. Strada regarding the budget? All right, great. Thank you. Number 17, Medical Director Report, Dr. Brett.
Yes, good morning, everybody. I'll make this brief as well. With respect to our experts, I do want to thank y'all for all of your recommendations and suggestions. DPRC tentatively approved 18 new experts for us to be able to utilize. We still do have some areas that we can continue shortages of experts. Certainly any licensed physician who is actively practicing, licensed in the state of Texas, is eligible just about with just a few exceptions, but we could use just about any specialty. But as far as our backlog goes, continues to be oncology is our most significant need, and we've got cases backlogged up to 9 months in oncology waiting for experts. So if you have any licensed physicians who would do a good job there, that's our most dire need. But we could certainly use physicians in just about any specialty.
Thank you, Dr. Brett. And Joey, remind me, was part of our budgetary approval allowing for a change in the remuneration for our expert panelists?
Yes, we did receive additional funds, and we're going through that exercise to determine how much that should increase, but we received a good chunk of change.
Yeah, so I know that the amount, of course, we're doing it for, expert panelists are doing it for service to the state, but it was way below probably what the market rates are. I don't think this adjustment will bring it up to market rates, but it will increase it significantly. So as you possibly talk to colleagues who are willing to serve as panelists, you can let them know that their time will be certainly valued as they help us in in reviewing some of these cases. So thank you. All right, with that, I will move on to Ms. Sloan as far as the public information update.
Good morning. Hi, everyone. So the last time you all met, we were obviously still in session and still had about a week left before the filing deadline. By the end of that deadline, TMB staff was tracking 341 pieces of legislation that could impact our licensees or our operations or just our staff in general. By the time the session ended, a couple days, well, maybe a couple weeks ago, only 25 of those 341 survived the legislative process. The vast majority of what we would refer to internally as high impact legislation did not survive. For example, I'm sure you all heard that there was a bill creating a PA compact, much like what we have for physicians, that didn't make it. There was a bill that would have created a new physician graduate license type for folks who've graduated from an accredited medical school but have been unable to match into a residency program. This bill would have allowed them to practice in a limited capacity while perhaps they continue to still try to match. There was another bill that would have, among other things, required us to have standard of care complaints reviewed by 8 expert physician reviewers as opposed to the current 2. And there was a slew of bills that would have created new CME requirements. None of those bills survived this session, but we do fully expect them to reemerge next session in some form or fashion, so they're only dead for now. Back to those 25 that did survive, about half of those are what I would refer to as state agency bills, meaning they impact all state agencies or maybe just regulatory agencies, but they aren't necessarily specific to TMB or our licensees. For example, there's a bill awaiting the governor's signature that would require state agencies to provide notice of our proposed rules to a bill author if it was a bill that required that rulemaking. Another example, which is also awaiting the governor's approval, is a bill that would grant state employees some amount of paid leave for the birth or adoption of a child without first having to exhaust all of their vacation or sick leave. As far as bills specifically impacting the TMB or our licensees, aside from the bills that have already been mentioned today, several others did pass that primarily concern TMB enforcement actions. And when I say enforcement actions, I mean the bill contains a provision that allows TMB to take or prohibits TMB from taking some sort of disciplinary action against a licensee. So an example of this, again, this bill also awaiting the governor's signature, it would expand the Right to Try Act to apply to severe chronic diseases and not just terminal illnesses. This bill contains a provision that prohibits us from taking action against a physician's license based solely on them recommending a patient to try a specific treatment, provided that that treatment meets the standard of care. Another good example of one of these enforcement action type bills is one that would require a healthcare provider to provide an itemized bill of the alleged cost of a service or supply that was provided. This bill contains a provision that would require us to impose certain administrative penalties on licensees for non-compliance. I think you all kind of get the gist. Overall, aside from the budget and the legislation related to continuous query and the PHP funding that was already mentioned by Dr. Zafran and Mr. Carlton, it was actually a fairly uneventful but successful session in terms of bill passed that would impact the agency. And of course, this absolutely works to our advantage because assuming the budget is signed as is by the governor, along with House Bill 1998, which is the bill that provides for the fingerprinting requirements and the NPDB continuous query, the agency is going to be plenty busy during the interim, hiring new staff and getting newly funded initiatives like the new website Dr. Zafran mentioned off the ground. Once the veto deadline is passed, that deadline is June 18th, by the way, it's a Sunday. We know, and we know exactly how these remaining 25 bills fared on the governor's desk. We will post an update to our website as we've historically done, detailing what was ultimately approved and when it will actually go into effect. Before I conclude my remarks, I just want to give a big shout out to Dr. Zafran for all of his help and support this session. He was very much so in the trenches with staff. And I know we're all really appreciative for his help. So thank you very much, Dr. Zafran. That concludes my update for today, but I'm here for any questions if you have them.
Thank you, Tori. And, you put in a tremendous amount of work and effort into this. So thank you for what you and the other staff have done. I know Mr. Carlton was at the Capitol for many, many hours, making himself available as a resource witness for the agency. I will just want to touch on the PHP bill because I didn't really exactly talk into a little bit of detail as to what that is. But as all of you know, the medical board helps bridge any kind of funding gaps that PHP may have. And I think last year it was to the tune of about $300,000, probably a little bit more than that, to support the efforts by PHP. When these physicians are voluntarily or non-voluntarily asked to have intakes by PHP, it is a significant cost on them, and possibly at a time when they are impaired and may not be able to practice. So what the bill has done, and I've got to give a tremendous thanks to Representative Julie Johnson on the House side and to Senator Donna Campbell on the Senate side for helping push this through. It increases our fees, our license fees by $15. And what that does is those fees specifically go to the PHP program and allows for any licensee to be able to go into the PHP program without having to put any additional monies out from their pocket at that time. So this will allow these licensees to get the help that they need. We all know about physician burnout. We all know that there are physicians that truly need the help that they need and may have been constrained from getting that help because of finances. So this bill, which is awaiting the governor's signature, will again allow these physicians and other licensees to be able to get that help without any additional cost. This also frees up the medical board for having to close the gap from the funding standpoint. So it actually made available an additional $300,000 plus from our side that we don't have to fund the PHP and bridge that gap. So again, thanking our legislators for being proactive and helping our licensees from that standpoint. Tori, the prior authorization bill, did that go through? I can't remember. So
it did not. That's a
Yeah.
good example of one that would have had a pretty significant impact on the agency, but it just did not survive the legislative process. I don't think it actually ever got a hearing in the Senate. I think that's where it stopped.
Okay, and I'm sure that's another one that will appear probably later on.
Absolutely.
This was an effort to make physicians who are working for insurance carriers acting as reviewers for insurance carriers as in regards to prior authorization, accountable to the medical board for the decisions that they make and holding them to the standard of care as they make decisions as it relates to prior authorization. I know this is extremely important from the standpoint of physicians wanting to make sure that insurance carriers who may not provide for prior authorization, that they are being held accountable to the standard of care in the community and not frustrating physicians and patients who are not able to get that prior authorization. I don't think the bill did not get a hearing in the Senate because of the merits of the bill. There was a lot of other factors that went in there, as we all know. A lot of bills didn't get hearings either in the Senate or in the House, not because of the merits of the bill, but because of other factors that played into it. So I'm fairly confident that this will probably come up again, as will the physician graduate bill, which I think was trying to address a significant amount of shortage issues. That it will come up again in the next legislative session. But anyway, again, thank you to Tori and to Brent for all the time that they spent, as well as other staff members, as well as other board members who also helped weigh in during the legislative session. Any questions by the board members? All right. with that, I will proceed on to, there is no update from the physician assistant liaison unless somebody wants to raise their hand. All right, seeing none, I'm going to proceed on to Mr. Freshour, consideration of possible action regarding pending litigation.
Yes, and thank you, Dr. Safran. I'm going to be fairly short and quick as well. We have a couple of substantial evidence appeals, which we almost always have, or say we have, you have as a board, where somebody challenges your final order from SOA. But nothing out of the ordinary on those. The two things that I do want to give you a heads up on that have occurred is the Philip Leonard case, which you took up probably, gosh, close to a year ago, and revoked his license for boundary issues. He's appealed that all the way up to the Texas Supreme Court, and the Supreme Court has asked our attorney generals to respond to whether or not the certiorari should be granted, which basically means the hearing before the Supreme Court. The gist of the argument is that the ALJ and the board alleged the wrong version of the rule in taking the enforcement action against Dr. Leonard. Where that'll play out, I'm not sure. We're just watching it. They've asked for the briefs on it. We don't know if the court will rule on it, but I will keep you apprised of that. Excuse me. The other case, just to have a heads up on, is if you remember the McMorris case. Again, been around for quite some time, but Dr. McMorris was the fertility specialist, I believe, up in the East Texas area. I think Dr. Zafran, if I remember correctly, who apparently used some of his own sperm for donation to the women that were getting fertilization treatments from him. We brought that against him for unprofessional conduct because he was not disclosing that he was one of the quote unquote anonymous donors. They appealed the rule that we had because, as you remember, a rule says you can't take up a standard of care case after 7 years, but any other type of cause of action like unprofessional conduct, you can. He tried to argue what he was doing was the standard of care. We argued, no, it was unprofessional conduct because it went to the deception related to the source of the donor and him being one of the primary donors. The court found for us at both the district court level and at the Third Court of Appeals. He filed a motion for rehearing at the Third Court of Appeals, and last week they declined to rehear his case. So for all intent and purposes right now, his last venue is he can attempt to go to the Texas Supreme Court and argue whether or not the rule is proper. We'll let you know if anything happens at this point. But those are the cases we have in litigation that you need to be aware of.
Thank you, Mr. Freshour. And I just will touch on that second case for a second, because I know that there was intense public interest in that case. And there was a lot of concern that the medical board was not did not act as strongly as it could have against this physician. But as Mr. Freshour indicated, we did what we could within the bounds of what the law allows us to do as with regards to unprofessional conduct, because it did come about after the statute of limitations. And we did act on this position based on the findings of unprofessional conduct, and we will continue to vigorously fight this if it goes up to the Texas Supreme Court, as a lot of folks were affected by this. It was a small community that this physician was practicing in, and not disclosing that he was one of the anonymous donors truly impacted that community. You can imagine in a small community like that, there could be possibly folks who are closely related to each other actually getting married or whatever it might be without knowing that they possibly might have the same father. So there was, again, like I said, intense public interest. We feel strongly that this physician acted extremely inappropriately. And again, just for the public interest, we did what we can within the bounds, and we will continue to fight for what we thought was appropriate as far as addressing this, as far as unprofessional conduct was concerned. So thank you, Mr. Freshour, for that update. And we will obviously keep everyone informed as this proceeds on, or if it does proceed on. Moving on, we have a lot of reports. Again, these reports are for information. If anybody wants to extract it to discuss it, we can do so, but there is not a vote needed for these reports. So item number 21 is report on temporary suspension hearings. Again, if any of you want to stop me and ask for it to be extracted for conversation or discussion, you can do so. Item number 22, report on suspensions by operation of law. 23, there is none. 24, there is none. 25, report on automatic orders. 26, there is none. 27, there is none. 28 is an action item, consideration and approval of revised, vacated, or amended orders. Is there any extractions or recusals on agenda item number 28?
So Dr. Zafran, you do have one item in front of you that would, if you want, need a vote. There was an order entered at the last board meeting that was inadvertently submitted with one finding that had been negotiated out between council and board staff. It was just an error, so we'd ask that you vacate the previously entered order and instead adopt the corrected order in front of you. It's that last finding E that you see in the order that's labeled as vacated. If you'd like to take that action, you would need a vote to do so.
So that is agenda item number 28. There are two items on there, and one item is to vacate the order. The other item is to adopt the corrected order. And because you can't exactly do both at the same time, I'm going to take each one individually. First, we would have to vacate the order, and then we would have to adopt the order. I'm not a lawyer, Amy, but I'm kind of getting there. So, so we will go first with agenda item number 28, item number 2, which is to first vacate the order as it was presented. Is there any discussion on that item?
Motion to vacate number 2 under item 28.
All right, a motion's been made by Ms. Barnes. Is there a second?
Second, Bhatia.
Seconded by Dr. Bhatia. Is there any further discussion? All those in favor, please say aye.
Aye.
All those opposed? All right, the item is vacated. So now with that, you have in front of you agenda item number 28, item number 1, which is to adopt the corrected order. Is there any discussion on that? Seeing none, is there a motion for agenda item number 28, item number 1?
Motion to accept the corrected version.
Motion by Ms. Barnes. Is there a second?
Second, DeStefano.
Second by DeStefano. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? All right, agenda item number 28, number 1 passes. Thank you. All right, as far as the rules are concerned, there are no proposed rules. So agenda items number 30 through 35, there is none there. Agenda item number 36, we've already had our forum for public comment. Agenda item number 37, discussion recommendation and possible action relating to personnel matters. With that one, I'm going to ask us to go into executive session for the purpose of discussing personnel matters. Is there a motion on that?
So moved, Barnes. Second, Barnes.
Motion made and it's been seconded. All those in favor, please say aye.
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 All those opposed? That passes, and I'm trying to pull up the prompt. I'm sorry. Okay.
While in executive session.
Yeah, I'm just pulling up the prompt so I can be specific. Sorry.
You good?
All right. So we've moved that we go into executive session for the purpose of personnel matters. The motion has passed. There being no objection, this meeting is now closed to the public at 9:43 a.m. June 9th, 2023. The meeting will continue in executive session for the purposes of deliberation concerning personnel matters under the authority of the Open Meetings Act, Section 551.074 Government Code, While in executive session, the board will not take any action, make any decision, or vote with regard to any matter that may be considered or discussed.
Great. And with that, we will be utilizing breakout rooms for the executive session. I'm going to go ahead and open the room, and the board members will all be swept over into the breakout room. For all members of the public that are logged into the meeting, you'll see the message on your screen here in this main meeting area. And once executive session has concluded, the board members will re-arrive back into this main meeting area. So just in a couple of seconds, and we should all be swept over into the breakout room.
And Alicia, it should be Chris and I going over along with Jeff, and I think those are the only ones, but definitely Chris and I need to go, but no one else from staff.
Okay.
And of course, obviously you, Alicia.
We have faith in you.
Sorry, Dr. Z. Okay, it looks like everybody successfully moved out and the recording is still going, so we're good to go.
Right, thank you, everyone. The executive session ended at 10:04 a.m. on June 9th, 2023. There was no final action, decision, or vote with regard to any matter considered or discussed in executive session. A certified agenda of the executive session was made. So still on agenda item number 37, discussion, recommendation, and possible action relating to personnel matters. Is there any discussion from the board members? I think Dr. Tibbles, you wanted to say something first?
Yes, and I'll have a motion too, if that's okay after others, if anybody else wants to chime in. So I think it's important just to share, based on my own observations of Brent's work in the last year, 2, 3 plus, however long it's been, and then discussions with those that, with whom he works closely, specifically those on the board who are on the executive committee and many others, just to share publicly what I've seen and then some of the themes that I'm hearing from others.
So we're talking now about the executive director, right? Just want to make
Yes,
sure
we're
that we're
talking
clear
about,
that
yes,
what we're
to be
talking about.
clear, yeah,
Yeah.
talking about our executive director. A few themes. One is several years of significant professional growth and a commitment to professional growth and leadership. And Brent has represented the board ethically and professionally and with high integrity in places including, our legislative efforts, things like the FSMB, and I could name many more. Just from an operational standpoint, I've seen this myself and I've benefited from this. Significant streamlining of process and gaining of efficiencies, which translates into significant fiscal responsibility, lots of growth, and really encouraging things in the area of staff and just people management. I think, if I can, I'll make a motion, but I guess I'll pause and see if anyone else wants to offer comments. I just want to, close this by saying just the highest praise for all of those things I mentioned about Brent, and we're really lucky to have him.
I second your praise of Brent.
Okay, I'm happy to make a motion if I can.
Sorry, my mic was off.
Okay.
Does anybody else have any comments? Okay, seeing none, Dr. Tibbles?
Yeah, I'd like to make the motion that we raise the salary of our executive director to the maximum allowed by the state.
Second, Barnes.
And just to be clear, this would take effect potentially on September 1st. Okay, so a motion has been made by Dr. Tibbles. It's been seconded by Ms. Barnes. Is there any further discussion? All right, seeing none, we'll proceed on to a vote. All those in favor, please say aye.
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 All those opposed? Are there any abstentions? All right, so the motion passes. And again, I would like to publicly thank Mr. Carlton, number one, for his service today as it stands in the military, out there doing what he needs to do, protecting our country, but also for the service that he's done for the medical board in helping streamline our process. It's a well-deserved raise that will take effect in September 1st. And I will relay to him personally the feelings expressed by our board members as it was stated here in public. All right. Next item is the consent agenda. I'm going to just take item number 1 first, consideration and approval of the March 3rd, 2023 medical board meeting minutes and action items. Is there any discussion on agenda item number 1 of the consent agenda? Seeing none, all those in favor, please say aye.
Aye.
Aye. Aye.
Those opposed? Okay, number 1 passes. And item number 2.
Sorry, did we
There's
have a motion and a second?
Yes, we did. I think it was Dr. Bhatia and seconded by Ms. Barnes.
I did, okay.
Yeah, I'll move if you don't have it on record. I'll make that motion just again.
Second.
Thank you.
Okay, we can take a vote again. All those in favor, please say aye.
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 All those opposed? All right, that motion passes. Number 2, committee reports and the consideration approval of minutes and action items of committees meeting during the board meeting. I will actually go ahead and extract 2 items. One is from the DPRC committee report from yesterday. There are 2 items that I'll extract. One is number 22-0479, and the other one is 23-2095. We can entertain each one of those individually and then proceed on to a vote on the rest of the committee items. With 22-0479, this is a this was a dismissal that wasn't a specific physician regarding their actions. And the only thing that I will propose in this item is a return to the expert panelists with a very specific question regarding this item in regards to the use of a specific medication that was given in this circumstance by the physician to this patient at that time. If I need to go into more specifics on that, I'm sure that Mr. Palazzolo will give me direction, but that is the only narrow item that I am proposing for this agenda item.
And so that would be, this is for case 230479 that was, 22-0479 that was voted yesterday. It was approved for those that were on the DPRC committee, that it was approved for dismissal. I believe Dr. Zafran is now pulling that out from the minutes for further discussion by the full board, and the recommendation then, if I got this right, Dr. Zafran, is to return to the expert panelists that reviewed that case and ask them to specifically review, I believe it was the medication given to the patient when the patient had a negative response during a procedure. We have the details, and get that specific question answered by the expert panel, and then bring it back to the DPRC committee at its next meeting in August. I have that. That was the intention.
That is correct.
So,
And I'll clarify
please.
one little thing that you said, Chris. So I think that this would be, it would not be amending the minutes, because the minutes are reflective of what the DPRC did vote to recommend, but it would be amending the action items or not adopting the action items from
Right, so what-
DPRC.
Right, what you would be doing is Dr. Zafran would be moving right now not to accept the recommendation of DPRC and to send it back for the purpose that he described, and you'll vote on this separately now, and that will be specifically extracted. Then when you get done with anything like that, you would just then do your regular approval of the consent minute, the meeting minutes and the consent agenda items as listed, other than these couple of Dr. Zafran has pulled. So yes, you're correct. So the meeting minutes for the committee would stay the same on the recommendation, but the board meeting minutes for this meeting will reflect Dr. Zafran's action if the board approves his motion on pulling this one.
Thank you. Dr. Quinones?
Yes. Dr. Zafran, would you consider amending that request from the expert witness, specifically addressing the dosing of that therapeutic agent or that drug, which is what I think we were, where there was some question.
Sure. I mean, whether it's the appropriate use of the drug or the dosing of the drug, I think is what we're getting to, but that's the gist of what we're asking for. Correct.
Thank you.
So a motion was made by myself. Is there a second?
Second, Dr. Quinones.
It's seconded by Dr. Quinones. Is there any further discussion by the board members?
I'm gonna recuse myself.
Okay, so Dr. Bhatia, for the record, is recusing himself. Any further recusals or discussion? All right, all those in favor, please say aye.
Aye.
Aye. Aye.
All those opposed? Are there any abstentions?
Obviously, I have.
And you're, yeah, I know you're recused for that. Okay, the motion passes. The second item is 23-2095, and I'm not sure that we need to take any action on this, but I wanted to make a statement in regards to this case specifically. This is a case that involved a boundary issue that was actually very troubling and that the board still has significant concerns about. It doesn't, even dismissing this case does not necessarily reflect the board's view that nothing potentially happened with this respondent in regards to the person who complained. The problem that we have facing us is that this case went to a jury trial. And in that jury trial, the jury, regardless of whether there was confusion, potentially because of judge instruction or whatever it might have been, at the end of the day, the jury unanimously voted to not convict the respondent. And because of that, it significantly limits our ability to weigh in on the specifics of that case in regards to the boundary issue that was there. I'm saying this because I want to make sure that the appellant understands potentially why we may not be moving further with this case. And it is certainly not reflective of us not believing in the merits of the appellant and the concerns raised as it relates to the boundary issues with this case specifically. For members of the public, this is still a confidential file, so I'm limited by going into more detail other than the actual number of this case, which is 23-2095. But it is important that I, at least from a very general standpoint, make the public aware as to why we may not be proceeding beyond that as far as considering the appeal, and why we potentially, if it's with the willingness of the board, dismissing this case. Again, not because of the merits of the appellant's request, but really because of our hands being tied with the jury action and the lack of conviction of this respondent specifically. With that, is there any questions, Dr. Tibbles?
Just really quickly, want to say thank you for making that statement and just fully support it.
Thank you, Dr. Tibbles. Any others? All right, with that, I am actually not going to make a motion on that case. The case was actually dismissed by the DPRC yesterday. And if the board votes as a whole on the DPRC issue matters itself, then this would automatically fall under that. Or do I need to vote on it because it was extracted specifically?
I don't believe so. I think you're just gonna, it didn't, nothing changed in the comment. Am I have that right, Scott?
That is correct. No, you're correct procedurally, Dr. Zafran, on exactly. It just goes back in with the others and will be voted on in mass as you normally do.
Okay, great. Thank you. So with that, I'm going to go back to the consent agenda item number 2, which is committee reports and the consideration and approval of minutes and action items of committees meeting during the board meeting. With that, I will entertain a motion on consent agenda item number 2. Devendra, you're on mute. It's not coming off of mute. Anybody want to make a motion on that?
Okay, no, I'm just, I'm having to make a motion, but am I okay to make one?
Yes, you are okay because you would be moving to accept the action items and committee minutes for all of the committees with the exception of the action item 220479 from DPRC.
Okay, I'd like to make that motion then.
Okay, Dr. Body has made a motion. Is there a second?
Barnes.
Seconded by Ms. Barnes and by Dr. Quinones. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? All right, motion passes. And Dr. Bhatia, you can thank me later for letting you get to your heart in time.
Well, I sent you a text just now. You can look at it.
All right, is there a motion for adjournment?
So moved.
So moved, Barnes.
Moved by Dr. Bhatia and Ms. Barnes. Is there a second?
Farmer.
All
Second.
right. All those in favor, please say aye.
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 All those opposed? All right, we are adjourned until August. And just real quick, everybody, I mentioned earlier that we are trying to aim for an in-person board meeting in October. It will really depend, of course, on the board being in place, the actual boardroom itself. So in August, I'll be able to give everybody a little bit more of a definitive answer. But that is my goal. I want us to be able to get together, all of us in one place for the first time since the beginning of 2020. So take care, everybody. Be safe. Enjoy the rest of your summer. Thank you.
Thank you, everybody.
Bye.
Be
Item
safe.
19 for the record.